Good morning, everyone. My name is Rob Weinstock. I'm a clinical instructor with the Abrams Environmental Law Clinic at the University of Chicago Law School, and it is my pleasure to kick things off this morning for what should be a great day of presentations and discussion around protecting our surface water and drinking water here in the region and more broadly. My role to begin things is to start with to provide an introduction to the primary federal statute that protects surface waters in the United States, which is the Clean Water Act. I'm going to do that by focusing on sort of the paradigmatic problem that act tries to solve, which is the discharge of pollution from industrial facilities to significant bodies of water. The way we'll proceed today is by starting with the basics of the Clean Water Act, what it prohibits, how it operates through issuing permits to entities who want to discharge into water bodies, how those permits and the law is enforced. And as we go, we're going to talk about some of the gaps in the law and shortcomings in its implementation, some loopholes in the way it was written, some of the intricacies of that permitting process that create issues, and then problems that arise in the enforcement context and reasons we might think that the law isn't being enforced to the extent it should be. Finally, we'll wrap up with a bit of a case study, looking at the litigation ongoing in the Northern District of Indiana, brought by the Surfrider Foundation against the United States Steel Corporation for its discharge of carcinogenic hexavalent chromium in April of 2017. As many of you, I'm sure, have read about in the news. The Abrams Environmental Law Clinic, where I work, represents the Surfrider Foundation in that litigation. And so we'll be walking through some of the details there as a way to highlight some of the things we'll talk about with respect to the Clean Water Act throughout this presentation. So first, the core prohibition of the Clean Water Act is found in the very first section, which is actually section 301 of the Act. It's the first substantive section, and that says there's a prohibition against the discharge of pollutants from a point source into a water of the United States. And if you look on the slideshow, that picture really indicates what the Congress had in mind when it passed that law. They were focused on big pipes spewing out dirty-looking stuff into clean-looking water bodies. And really, it was a law that was passed against the backdrop of all of these industrial facilities cropping up around the country up through World War II and through the 1960s and the birth of the environmental movement in that decade. And the Clean Water Act has many other provisions beyond that prohibition related to research, related to particularly important water bodies like the Chesapeake Bay, related to funding publicly owned wastewater treatment, and protecting wetlands. But this prohibition is at the core of the Act. And for those of you who are starting to think like a lawyer as we sit here in the Valparaiso Law School, you might start to imagine that the definition of those words up on the screen are quite important and are where a lot of the Act, really, the rubber hits the road for the Clean Water Act, so to speak. The definition of pollutant in the Act is really broad. Anything added to a waterway. That could be a toxic chemical like hexavalent chromium. It could be garbage. It could be heat, just hotter water than was in the water body beforehand. Anything that can affect the ecosystem or the public health qualities of that water body. The definition of point source in the statute starts out very broad. Any discernible, confined, and discrete conveyance. Sometimes we like to joke that it's anything you can point at is a point source. So if you can identify this is where the polluted water is coming from or the wastewater is coming from, that is a point source. We'll talk a little bit about how that broad definition gets carved away, and you'll hear from Aaron Korn from Hoosier Environmental Council about one specifically problematic exception to that rule in the context of confined animal feeding operations in just a few minutes. Finally, that definition of waters of the United States. That might be something that's familiar if you read environmental news, and it basically has to do with the authority of the federal government to regulate. So it has to be a significant enough waterway that it merits federal government intervention. And that's really the first shortcoming of the first loophole, that idea of waters of the United States. That term, as I said, ties back to the power of the federal government. The Supreme Court in the 2006 decision in the Rapanos case created a whole mess, and that cartoon is kind of a witty little reminder of it. That 2006 decision didn't have a majority opinion. It had 3 different decisions, 2 of which had 4 justices voting for them, and 1 swung that case, and it was Justice Kennedy in that instance. And Justice Kennedy's opinion focused on whether there was a significant nexus between whatever water body is being polluted and a navigable water, so a big water body that everyone agrees is within federal jurisdiction because you need it for interstate shipping, for example. Justice Kennedy's decision was the basis for the Obama administration's attempt to define that term in a 2015 proposed rule, which would have used that significant nexus test and applied the Clean Water Act to anything that has a, quote, hydrological connection to one of those navigable waters. So anything that is, in fact, related to the way that one of those waters works would be counted under this definition of a water of the United States. As you might imagine, the current administration takes a slightly different approach, or dramatically different approach in this case, and looks at another one of those decisions, the minority decision that was penned by Justice Scalia, which would lead to a much more narrow definition of waters of the United States. And the 2019 rule doesn't ask the sort of site-by-site factual and scientific question, but instead would exclude any water bodies that don't connect to a major water body, a navigable water body, every year. It would exclude any discharges into groundwater, even if that groundwater leads directly into a major water body, would exclude ditches or quarries or irrigation infrastructure that leads again directly to major water bodies, and would also have various other carve-outs that would make the rule much narrower than the 2015 version, so would really hold back from Clean Water Act protection many water bodies that would be protected under the 2015 rule based on Justice Kennedy's decision. Another big area where the law carves out big sources of water pollution is in the definition of point source, as I mentioned, carving out stormwater conveyances, carving out major agricultural, industrial agricultural facilities, as you're going to hear about in a few moments. And there the story is really about the political power of agriculture when the act was being passed. And they are regulated under the Clean Water Act, but under this umbrella of best management practices. They get these very general rules about practices instead of focusing on the actual prevention of pollution. So remember, you've got that prohibition against discharges, but the biggest exception of all is you're allowed to discharge if you have a properly issued permit. Under the Clean Water Act, permitting is generally done by state agencies. Here in Indiana, it's the Indiana Department of Environmental Management. And as long as that state agency convinces US EPA that they have the resources to administer a program, they're allowed to do that. And when they do issue permits, they're basically looking at a couple different things. They're going to include in that permit substantive limits, so how much of what sorts of things can you put into the water. And those are generally called effluent limitations. Sometimes they're expressed as a specific number or a concentration. Sometimes they're more narrative, like you shall not discharge more than the water body can handle. And they're derived either from technology-based limitations or water quality-based limitations. So technology-based limitations basically look at an industry and say, in this industry, this is how much of a certain chemical should be discharged from your effluent based on the type of factories you run, for example. Water quality-based effluent limitations look at the health of the actual water body. So for the technology-based limitations, Again, they're industry specific. They're generally promulgated by the US EPA because they look nationwide at an industry, and they're promulgated sort of not that frequently by the federal agency. Water quality-based limitations generally are determined by the state agency, which has should have more knowledge about the local water bodies, and they rely really on the science developed at the state level and a state agency's monitoring, which you're going to actually hear a little bit from Professor Peller later today about some of the really tremendous work she's done looking at how understudied water bodies are in Indiana. The other bullet points up there, operational requirements, monitoring and reporting requirements, are the sort of other pieces of the permit. Monitoring and reporting, operational requirements, refers to basic housekeeping requirements, things that the discharger has to do to make sure they're responsibly running their wastewater treatment operations. Monitoring and reporting requirements is an interesting issue we'll talk about in a few moments, because the norm here is self-monitoring and self-reporting. So the discharger is typically required to collect certain samples on a periodic basis, analyze them, and submit monthly reports to the state agency describing whether or not they're complying with their permit. As you can imagine, that leads to several gaps and shortcomings that show up in the permit process. So first, as I mentioned, both for the water quality-based effluent limitations and the technology-based limitations, the science is outdated. Guidance documents, which are the formal papers that the agency puts out to say how should these limitations look in permits, those documents themselves are outdated. So a good example of this is if you look at the technology-based limitations for the steel industry, those were last updated in 2005, almost 15 years ago. It's pretty shocking. But those are actually some of the most current guidance out there. The metal finishing industry, sort of a related industry, those limitations were issued in 1986. Many other industries haven't had their guidance documents updated since the 1970s when they were first published. So you can tell the need to update these things and keep up with the commercial world is real. There's always the issue of agency resources, and because the agencies don't have tremendous resources, they rely on the applicants to provide a lot of the information that goes into the permit process. There's a whole host of sort of administrative tricks and tools that dischargers can use to gain even more flexibility, even when there looks like there might be a real rule in place, a firm rule in place. And finally, there's the monitoring issue that I mentioned before. Many times dischargers will say, well, it's not practical for us to monitor every day. Let us monitor twice a week. Well, and the agency may say, well, okay, that's fine. We'll let you monitor twice a week. But then the discharger will choose to monitor on Saturday and Sunday when the factory is not even running. And that could be perfectly consistent with their permit, but obviously it kind of defeats the whole purpose. And so you see a lot of those sort of games played around, well, how can we average these numbers, or how can we schedule our monitoring in ways that don't tell the full story of what's going on at our facility. And that's important because that self-monitoring and self-reporting are the basis for the way the Act is enforced in many instances. So the first thing to know about enforcement of the Clean Water Act is the enforcement provisions apply if you break your permit or if you discharge without one. Either way, you're violating federal law, and the state agency or the federal government can bring a case against you. The Clean Water Act actually has some real teeth to it. The penalties that it authorizes are up to about $55,000 per day per violation. So that actually can add up quite quickly. But penalties are almost never assessed at that level. There are various reasons which I can get into perhaps offline for why that doesn't happen. Another powerful or potentially powerful aspect to these penalties is that it's what's called a strict liability statute. So it doesn't matter what you meant to do. If you ended up discharging pollution into a water body without a proper authorization, you have violated the law. So it doesn't really matter if you tried your best, or if you were sick that day, or you're a key personnel member sick that day. If you violate the law, you violate the law. What you see on this chart a bit is the breakdown, and I know the font is small, I apologize, but the breakdown of enforcement actions as between actions brought by the federal government versus state government, actions that are taken in an administrative setting, i.e. sort of a ticket from the US EPA or an administrative citation versus judicial cases that are brought in court. And you see some of the penalty numbers that were recorded in those different types of cases. The last bullet point I want to mention is the possibility for citizen suits under the Act, and that is the type of case that we're dealing with in the Surfrider versus U.S. Steel litigation. Citizen suits are not unique to the Clean Water Act, but are a common tool in many environmental statutes. And the basic principle here is if the federal government and the state government are not taking an action to prevent violation of the law or to penalize it, then any member of the public who is affected by that violation can step in and bring a suit themselves. So if you violate the Clean Water Act or your permit under the Act, you could be enforced by the state agency, by the federal agency, or a citizen or citizen group can bring a case against you. If it is a citizen suit situation, those citizen suit plaintiffs have to send what's called a notice of intent to sue to the violator, and they have to send copies of that notice to the government agencies before they file their case in federal court. The idea here being that gives the federal and state governments a chance to actually step in and do their job, and if they do so, that the citizens' lawsuit shouldn't interfere with that government enforcement action. But the citizens should be allowed to intervene in the government's action to participate nonetheless. So I've already been hinting at some of the gaps and shortcomings that you might be thinking about already in terms of the enforcement context. So the first is that self-monitoring issue. You can game the system really easily. I mentioned the weekend sampling kind of phenomenon. Another interesting one is averaging. You may have a permit limit that says you cannot exceed a monthly average, but it doesn't say how many times you have to sample. So you sample on day one of the month, you realize you're way above your limit. You might change something in your facility and then sample a bunch more times during the month to get that average number down. That, again, can be perfectly permissible under the permit, even though it is defeating the purpose of protecting the water body. Cooperative federalism is this idea you might be hearing about recently, which is the notion that the states are supposed to be working with the federal government to enforce environmental laws. That's always been the case. The current administration has taken a particular view of that idea and said they're not going to bring enforcement actions unless the state actually asks them to do it. This point about agency resources again comes up. Agencies don't have the resources to do enough inspections or to monitor facilities as closely as they should, and they rely on industry to provide information about what's going on. Additionally, you see more and more that political leaders are really forcing agencies to consider industry's perspective much more than considering just sort of the public interest perspective or the concerns for environmental issues. Michigan, in fact, has a law requiring all environmental rules to go through an advisory panel that is full of industrial representatives, or at least the balance of it is tips toward industrial representatives. And that also raises the issue that sometimes, industry experts really do just know their facilities better than government agencies. Who knows how to run a steel plant better than a steel industrial engineer? And there's some truth to that. And so that means that agency officials are even more likely to defer to the violators, really, in understanding what's going on. Finally, the limitations on citizen suits. I pointed out this notice requirement a moment ago, but also just remember that citizen plaintiffs don't have the subpoena power that the government does. They can't inspect a facility unannounced. In fact, they can't get onto a facility property before being in the context of discovery at all. So they're forced to rely on public documents, on those monitoring reports that I mentioned before, which again runs back into the self-monitoring issues, and sometimes just observation, just sitting on a fence line and looking to see what's coming out of a pipe. Finally, they don't have the resources or expertise that the industry does, or even the agency, and it can be expensive to do one of these cases. let's pivot now and talk about one of these cases. And again, I'm going to circle back to this Surfrider case against U.S. Steel. So here's an image of our clients. On the left is the real deal, although that's a picture that was taken in whiting. On the right is a fictionalized representation of what they're doing. We've been working with the Surfrider Foundation, the Chicago chapter, for almost 2 years now. And they originally approached us, for over 2 years now. They originally approached us just because they knew where they surfed in Northwest Indiana. They knew it was near these big industrial facilities, and they wanted to know what they were surfing in. So we started looking into that question using the legal tools we had available to us. We started looking at, well, who's actually discharging? We looked at all those self-monitoring reports, and we looked up the permits that were issued, and we confirmed what you knew with your naked eye. There were tons of big industrial facilities that were discharging wastewater in the area, and there were publicly owned wastewater treatment plants that were discharging in the area. Next question, naturally, is are they following their permits? Setting aside the question of if their permits are stringent enough, are they following them in the first place? Turns out, no, they're not. And what you can see in this image, which our clients at the Chicago Surfrider worked with us to prepare, is a number of facilities in the area, and it's hard to read, but that's part of the point here, is to be overwhelmed with the information that's available. You can see all of the violations, and what this shows is some of the worst violators that we pulled out. Discharges that had violated for multiple quarters consecutively leading up to when we generated this chart. And one thing you'll see here is that the penalty numbers, particularly for the industrial dischargers sort of along the lakeshore there, the top of the screen, those penalty numbers are very small. What you see is when there are any penalties or any enforcement action taken, it's typically a state administrative action, not a judicial action, not a federal action, and the penalties are often a couple $1,000s. And yet you will see some of the largest companies in the country listed there, and so you can ask the question, what does an $8,000 penalty really mean to an international conglomerate like these? So we were looking generally in the winter of 2016 into 17, we're looking at water quality in the south end of Lake Michigan. And that, of course, is when April 11th, 2017 happened. U.S. Steel spilled an estimated at least 300 pounds of hexavalent chromium, roughly 300 pounds of hexavalent chromium into the Burns Canal. It closed beaches. It closed drinking water intakes in the area. It threatened the drinking water intakes run by the city of Chicago, which serve millions of residents in Illinois and Indiana. And it was a catastrophe, I think, to say the least. So we focused, I think it's fair to say, on U.S. Steel, pivoting from this broader regional kind of research project to actual litigation. Throughout spring and summer of 2017, we were researching, we were filing public information requests to find out what was going on at U.S. Steel and whether this was part of a bigger pattern of violations or whether it was an isolated incident. And we discovered that it was part of a pattern, and there were dozens of Clean Water Act violations at that facility over the preceding 5 years. And so in November of 2017, we filed our notice of intent to sue, that formal first step in bringing a citizen suit, because there had been no state or federal enforcement action brought at that point. And what was really striking is right as we were getting ready to send that letter, U.S. Steel violated again with respect to chromium discharges from its facility, and that's what you see referenced in the Tribune article on the right part of the screen there. In January 2018, the 60-day notice period ended, and we filed our lawsuit in the Northern District of Indiana. And U.S. Steel answered our lawsuit in March and actually admitted to dozens of the violations we alleged. And then in April of 2018, finally, the federal government and the state of Indiana filed their own enforcement action. And of course, on the very same day that they filed that action, they announced that they had already settled it with U.S. Steel. And so our attention really shifted again to focusing on that U.S. and Indiana versus U.S. Steel case and think about whether their proposed settlement was actually adequate. Did it punish U.S. Steel sufficiently for their pattern and history of violations, and would it prevent any future violations? We submitted comments on that in the summer of 2018 along with thousands of other members of the public. And in fall of 2018, we formally intervened in their lawsuit so we could have a seat at the table and present to the judge our arguments around why that consent proposed consent decree was inadequate under the law. Couple updates you may have seen in the Northwest Indiana Times or other local newspapers. In November and December, U.S. Steel violated its permit again with a suspicious foamy discharge on a number of days. And in December, after receiving more public comments from Surfrider and others, ITEM actually required U.S. Steel to start testing the groundwater more regularly moving forward because it had observed hexavalent chromium in the groundwater that appeared to be related to the April 2017 spill, but that U.S. Steel and ITEM had no idea if it was actually reaching the Burns Canal and being discharged. Government now is still formally considering comments on that proposed consent decree. They're still considering the comments that were submitted, and we are just waiting for the government to indicate whether they will try to revise that consent decree, try to move forward with the existing decree, or scrap it and seek stiffer penalties and more relief from U.S. Steel. Obviously, we are standing by and ready to advocate for that last option, but we are waiting, like all of you, to hear what the Department of Justice and the state of Indiana come back with next. I've already taken up far too much of your time. I very much appreciate your attention this early, first thing in the morning, and I look forward to being here and hearing from the following speakers along with you. So thank you all, and look forward to speaking with you soon.